This video explains how to prepare for a motion in family court and what happens at one. Check your Form 14, Notice of Motion, for details about the date, time, place, and type of hearing you'll have. Your hearing can be in person, online, or it can be hybrid. This means that some people are in court and others are online. Contact your local court if you need to make any changes. If you are bringing the motion, you are called the moving party. If you are responding to the motion, you are called the responding party. Not all motions have hearings. Sometimes, a judge will decide based only on the written evidence you and your partner gave the court. In these situations, a judge will read your documents on the date given in the Form 14 Notice of Motion. If you have a hearing, both you and your partner must tell the court that you'll be there. You each do this by filling out Form 14C Confirmation. If you can, talk or write to your partner before filling out the form to see what you can agree on. Then, write down the amount of time you think you will need, the specific issues you want to talk about, and the documents the judge should read. Most motions are short motions that usually take less than 1 hour. A long motion usually takes over 1 hour. Check the court's website for the practice directions or rules about the length of motions that apply to your local court. Contact the court if you need more help. Give your partner a copy of your completed Form 14C. Then file it with the court no later than 2 o'clock in the afternoon, 3 days before the hearing. Filing means giving the court your documents to add to your court file. You can do this online or in person at the court. The court may allow some documents to be filed by email. If you miss this deadline, the hearing may not happen and you'll have to get a new date. A factum is a statement you write that says which law applies to the facts of your case. The court's practice directions will say if you need one. There is no special form. You can use a Word document. Write factum at the top, then include the court address, your name, your address, and your partner's name and address, like on your other court forms. Factums must usually be served and filed at the same time as the Form 14C. It's a good idea to make notes before your hearing about what you want to say. The judge will speak first to find out who everyone is. Then, you or your partner can ask to deal with procedural issues. You might do this, for example, if a document is late but you still want to rely on it, or if you have already settled some issues. This is also a good time to check that the judge has all your documents and that you have all your partner's documents. Next, the judge usually gives you and your partner a chance to speak. This is called giving an oral submission. Tell the judge what you want. There are usually no witnesses at a hearing, so you can only refer to the evidence in your affidavit or other documents that you filed with the court. Explain how the law applies to your case. You need to behave in a certain way at your hearing. For example, only one person speaks at a time. The moving party speaks first and explains why they should get the orders they're asking for. Then, the responding party explains why the moving party should not get those orders. If the responding party also brings their own motion, they explain what orders they are asking for. This is sometimes called a cross motion. The moving party can then reply, but they can only speak to anything new that the responding party brought up, and the judge may ask questions. The judge can make a decision at the end of the hearing or later. Making a decision later is called reserving the decision. This might happen if the judge needs more time to review the evidence or the law. You may have to come back to court to get the decision, or you may get it in writing. The judge can also order costs. This means they may order you to pay some money towards your partner's legal fees, or order your partner to pay some of your fees. Usually, The person who gets the orders they asked for gets costs. But the court also looks at other factors, like whether a person was unreasonable. The judge may ask you questions about costs. Here are some things you can do to prepare. First, make a list of all your legal fees and what the fees were for. For example, say which documents a lawyer helped you prepare and how much time they spent. Second, tell the judge if you made an offer to settle any of the issues. This may show that you tried to avoid a hearing. Third, explain how having to pay costs will affect your finances. For example, you can refer to your financial statement to show why you cannot afford to pay a large amount. After the hearing, your case usually continues through the family court process. You must follow any temporary orders until either a judge makes a different decision or you and your partner agree on how to resolve your issues. Use Cleo's guided pathways to fill out your court forms. To learn more about motions and family law, go to stepstojustice.ca/motions.